1 hour break.
Yeah, that's what I think we'll do.
I'm not eating.
Sorry? 5
Yeah. Yeah, let's get the same one. Let's get, oh yeah. Let's get the same one. And then we can have a picture.
We'll get great and then everything has very like deep jump on the
I got some great new friends from all over the world. You know, to catch your phrase.
Any city questions?
Yeah, like 80%.
How did he respond?
Huh?
How did he respond? Did he do anything?
No. He responded to them, and you know, as is the case, it was pretty much just a recap of him explaining it differently than what we already did. No.
There's something to explain.
Yeah.
Any interesting ones or you just do it?
Yeah,
You're going to keep it to yourself?
First, the book about conflict of laws, definition of loans, and then regulation. And regulation.
Anything which you like?
Huh?
Anything you like?
Yeah, I think it was.
Yeah, I know.
It's like, these guys, well, get to know.
Wasn't anything I didn't knew before.
I'm sure Philip had a bit shock to his system when he went in that room and we've been saying what you can't.
Yes, every time you say something that's correct.
Well, they talked about the first chapter and told how he explained it to me.
Yeah, so he explained the same way he explained it.
So he explained it again. Spent like 30 minutes on that.
30 minutes.
An hour, but it felt like long because he had already. He first explained just without explaining what people were confused about. I was the nice guy raising my hand and saying, I think what people are confused about is when I gave him an example with 4 points. And then he explained that. You can have it. I think it was going over. Mistakes. You can even go a bit faster speed.
Yeah, mostly
Like,
questions really.
I don't feel like I have to go over it. But as a slave, because I have every word.
I don't think there's many more things I'm really into. I think maybe make myself a bit clearer enough. Curious if you want. And then, I mean, complex laws, we've done it so much now. There's about anything I need to do.
I would like to imagine the recap of conflict also like all the things and like negative flags and like ceases and constitutions.
That's true.
It was nice with the recap and also in terms of going to the other
Yeah, it would have been helpful to see this That's all that was next.
You did, right?
It's sold out.
You too.
It's sold out. That's why I told you. I'm scrolling the chat. Tired now. Then like it's gonna be so. You even answer. I think getting my mom. It's not very often. was a long months ago.
I don't care how much I have to pay.
I used to work apart 67 pounds, 2 months before I left it.
I can still buy it.
The part is just that you still can.
I don't remember it was the no, he said it. Well, my parents. He even said he would buy it early, so that's surely not right. Like, I don't think it will let you catch up. Instead of giving money back to the shadow, what you give them something else back. In case of image. You can divide the shares and the emergency you create, or you can just the assets. So look at this, this is where it's so basic example. Company with capital they demerge, say, 30 of the capital into a subsidiary. They still have 100 capital in the main company because, you know, the subsidiary is an asset. Yeah. Okay, so look at it. There's 100 in the company, and then you have different departments within the same entity, and they might be different. So you say the sports department, say clothing, so take the clothing department, and one way you could do it was to make this a company, for example, transfer it into a company, and you reduce this capital. You don't have to, but you could.
Why would you want to?
If you want this subsidiary, if you want the sports shop in the hands of the shareholders instead of in the hands of the company, like then they could sell it on.
So we were saying about reducing your share capital because you have too much. Yeah, but then you might, if you broken up, spun off that part of the business into a new company, you might want to reduce your capital this one because it's now. Issue shares as consideration.
So it's always just that the shareholders have shares in two different companies afterwards instead of only one. Because you reduce the big company, the big clothing shop.
I don't think it's a reduction.
That is a reduction.
It's not a reduction of capital.
Yes, it is. It goes from 100 to 70 capital because you spin off 30. Spin off a small shop which represents 30 of your capital.
But that's if you accordingly reduce the capital, you know. What's happening is that
You're moving the assets rather than
company one spins off part, basically shifts its assets over to here, which in exchange, this company over here in exchange gives the company shares. So then it's like the shareholders, company, and subsidiary. But there's no reduction in capital here, there's no reduction of assets. I have to go over the
That's confusing. You have that effect on your
You
mind.
know how it feels.
No, yeah. drinks thing, come on.
I might do. I did say that, but
This is exactly how I explained it. And he made it so reduction.
You think you explained right now?
Yeah. You have it all in one company, and then you have the shares in two companies.
Yeah, I know that, but I know some ways that the customer is trying to implement. You can implement that without saying
No.
all you do is
How are you going to move assets out of this company?
and that's what I'm saying. And that's what I'm saying. When you start to write in consideration, so receiving to receiving company, if you share, so that's completely
Yeah. But I see that is one way of doing it, but the other way of doing it is when there's also no buyer, you can still do it. Just by putting the assets into a new entity.
because legally, new entity pay is the buyer.
yeah. And they say buy is like in share. So you can give it to the parent.
Yeah, which is the shareholder.
Yeah. I don't see how that's reduction. You can say something that you've given them equal return. Maybe you should go to the visual process.
Yeah. Okay, so uh, if you recall, last week I think we talked about the problem of recharacterization and trying to fit in, trying to consider the considerations which determine whether the court would respect the contractual choice of the parties. And the reason I mentioned this was that this tends to be the major issue which comes about in these dealings, and we call this recharacterization risk. And the leading case where we see this, I know we talked about one case, the case involving the LI11, if you recall, but we hadn't considered the Spectrum case. And I just thought to say one or two things about the Spectrum case. Obviously, I provided copious notes for you on Spectrum. But essentially, the issue in that case was it had to do with the construction of Clause 5 of a charge instrument, which was in the financing documents that Spectrum had. Clause 5 was a standard clause. It goes way back to a case that had been decided over 20 years ago. And essentially, the market, i.e. the banks and borrowers, had coalesced around this particular kind of clause, which essentially allowed banks to create, or rather to retain, a fixed security over book debt, so what you call account receivables, even though the company would have management autonomy to deal with the assets. By this I mean the borrower, right, has money coming in, right, because people owe the borrower, right? These are account receivables. We call them book debt. So it's constantly coming in. What this case had established, this case was about over 20 years ago, it had established that, well, a bank could retain a fixed charge in these sums which were flowing in, even though the company, the borrower, had a certain degree of autonomy in regard to this money. And what do I mean by autonomy? Autonomy at two levels. One, to collect it, right? So people owe you, you collect. And B, having collected, to, for instance, assign it, right? To factor it. So, so in a sense, the borrower is managing its company as if nothing has changed. You know, people owe you, they pay you the money, and you discount it. You take it to a factor. Assuming you get the invoices, you don't even wait for them to pay. You take the invoices to a factor and say, please pay me a certain proportion of it, right? So the money goes into your account also, you spend it. And now this worked very well for the banks because essentially the banks had a fixed security, and it therefore meant that they were not subjected to preferential claims. Now preferential claims will be those creditors that have priority by law, such as employees, right? So if a company goes into insolvent liquidation, the employees normally are preferential creditors, and they just think about national insurance contributions and things like that. So they normally will take a huge slice of the assets. But if the bank has a fixed security, then the bank would be the first. So, so this is really important for the banks. Do we, if the courts say that what we've done is obtain a floating charge, then we lose priority to these preferential creditors. If, on the other hand, we can convince the court that what we have is a fixed security, then we have priority over these creditors, right? And the class of preferential creditors was large. It even previously included a taxman. I mean, but there has been a change to that. At least, you know, the crown debts are no longer preferential debts. So that was the context. So, so there were two things. One, what did the parties call it? The parties called it a fixed security. Remember, I said, what you call it does not really matter. If you like, call it a dog. If it behaves like a horse, and it doesn't bark like a dog, then maybe it's a horse, and not what you've called it. So the label of the parties is not controlling. It's an indication, but it is not determinative, right? So in this case, they called it a fixed charge. So you go to the next step, which is, what is the nature of the rights you have created or retained, right? Notice I say created or retained, because if I have property and then I essentially retain certain rights, right? Essentially what it means is that I have a proprietary interest, right, in it. So the idea basically is what sort of rights come in. So this would depend on a construction of the agreement. Now this is what happened in the House of Lords here. They had to consider the agreement of the parties. And when they looked at the agreement, they discovered that Spectrum was free to collect the book debt, but then had to pay the book debts into an account, which was called a blocked account. So Spectrum has managerial autonomy to collect the book debt, and then pay it into an account which they called a blocked account. However, it wasn't really a blocked account because they could dispose of it. And the court basically says that the freedom to do that is incompatible with the nature of a fixed charge, right? So that freedom, I mean, think about it in the context of your home. If you have a mortgage, you're not free to just sell your house. You need the bank's consent. So if you say, well, I can sell my house without the bank's consent, then maybe you don't really have a fixed security, or rather the bank doesn't have a fixed security. So this is what you see the court basically doing. So there are two stages. We look at the label, right, to work out the contractual intention of the parties, and then as a matter of law, the courts move on to the second stage, which is one of characterization, not recharacterization, of characterization. So when they get to the stage of characterization, they look at what you have actually drafted. What kind of rights are we dealing with? So in this case, the court basically says, well, it's not enough to have dealing restrictions. All right? It's not enough to say, okay, the dealing restrictions, you can't assign it and all that, but guess what? It goes into your account, you can withdraw. Did you get it? You see, so you need the block to be at 2 points, right? So dealing restrictions, i.e. you receive the money from your debtors, you cannot assign it, you cannot factor it, you can't transfer the debt, you take the money, right, the debt, you put it into this blocked account and then treat the blocked account as a blocked account. If you go to the blocked account and withdraw money, then it's not really a blocked account, right? If you withdraw money, it's not a blocked account. Now the bank said, well, it is a blocked account because we, the bank, have a lien over it. And the court said no, because the contract between the customer and the bank, you know, the relationship between a bank and a customer is one of creditor-debtor, right? So the creditor, the client, sorry, the depositor, essentially is the creditor. And the mandate is for the bank to honor checks drawn on the account, subject to any kind of overdraft facility. So if that is our relationship, i.e. you are obliged to respect my mandate, to allow me to cash my checks, then you cannot really say you have a lien over it, because because actually it's your property. How can you have a lien over your property? Do you get it? It's the bank's property. You can't have a lien over your property, right? And this tends to come up in a number of contexts where sometimes people get the characterization of these things wrong. So anyway, to cut a long story short, you see the court basically taking that view. And then, but because this was a big problem, because, you know, the earlier decision, which allows for the ossification of Clause 5, was a case called Sid Gorman, which was decided 25 years ago. And the entire market had proceeded on that basis. So this was a big earthquake. So the question was, what do we do about it? Do we make this prospective for the future or retroactive? What would you do? Retroactive or prospective? What comes in? Prospective. So, by the way, you understand separation of powers. So who elected you to pass laws? Because if you make it prospective, you're legislating. You say, I am Miss George or Mrs. George. I am now legislating for the future. If it's retroactive, you say, the common law has always been there. I just discovered it. Right? So it's, when we say it's retroactive, it was always there. It's not like we're making anything. Right? So Slate J in Sid Gorman only got it wrong. He got it wrong. And so, you know, what rights do I now have to change the common law of England when I'm not Parliament? That's why I said, do you understand? You know, that's why I talked about separation of powers. Right? Any questions? Any questions? Yeah. Okay.
So if the borrower needed a consent every time he wanted to draw from the account, this would be recognized as a...
Yeah, that's a good point. So if you go to meet the bank and truly get the consent of the bank, then yes, it will be consistent with the nature of a fixed charge. Now, the real difficulty, though, is if it is drafted that way, but consent is always automatic. Right? But you see, but then the problem is, I'm sure you can see the problem. The problem is that if consent is always automatic, right, then, as the judge said in the House of Lords, it's not enough to call it a block account. It has to be operated as such. That's the line. That's the line, right? But there are difficulties there because when we construe a contract, we don't look at what happens after. We look at the contract as it is. Do you get it? We don't the contract is not a chameleon that everything depends on what people do later. And then today it behaves this way and all that. I was dealing with, this comes up, I'll just give this example. I was dealing with an LCIA arbitration where we were trying to sort of work out the meaning of a clause, and the argument was, they were basically trying to look at hedging, right? Hedging activities by one party to construe, but that's post-contractual. And my point is that you can't use post-contractual things to work out the intention of the parties. You need to look at how things were at the time you entered into the contract. So that's, and even the House of Lords in this case, you know, then did recognize that there are deep waters here and all that. Right? Any other questions? Yeah, okay. So if you remember, there was a page on that seminar sheet where we talked about the issues to consider. I know that would be a matter of tremendous importance. The issues to consider when taking security. Recharacterization risk is a big thing, and we've seen this in the two cases. So what we want to do here, I thought to kind of set the scene for next week, in the sense that we're basically bringing sort of life cycle theory. Life cycle theory is from sort of finance discipline, which basically talks about the life of companies. There are basically four points in the cycle of a company. It's life, and within this context of life cycle theory, you'll notice, by the way, I kind of insert redomiciliation in it, right? So I expanded from 4 to 5, but it doesn't really matter. But within this context, what I want to do is integrate, right, equity and debt, and so that we apply them in an instrumental form, and that just sort of ties up some of the things I've been talking about. Okay, so here we say to bring our learning on equity and debt together in two different transactions. So the debt equity swap is what I'll talk about today. What you're going to be talking about, that is hopefully after this class next time, will be the private equity one. In other words, I would like you to reflect on the private equity side, right? So within so what I mean here by debt equity and then private equity is that within the life cycle, you have a company, the company grows, then the company has financial problems. So because the company has financial problems, we then want to do a restructuring to save this company. And we're going to consider a number of options. And if we coalesce around a debt equity swap, we're basically saying to the creditors, the banks, that you have debt, can we swap it into equity? Now, but if you check the Companies Act, you're not going to see any provision dealing with debt equity swaps. There's no section that says debt equity swaps. But because we, by now, should be aficionados in the business, we know that the way to proceed would be to get the debt to be converted into equity. And somebody else would say, well, you've got to pay for shares. But we would say, no, we don't need to pay for shares in the typical way, because we know about Section 583, which basically talks about how you pay for shares. The release of a claim for a liquidated sum is regarded as payment in cash. Right? So since I remember we've been talking about this, since I am owed money, right? Rather than ask the company to repay me the cash so that I then give the company cash back and take shares, I can just cancel it and take everything, right? So that way we don't run into the problem of Rio Regum, no discounts, not paying for shares and all that. That's just one example, right, of how we do it. So, okay. So here, I say a company is, you know what, let me move this into an app that will allow me highlight. Okay, so here we talk about birth, right? So that's the sort of life cycle, right? And as I said, what I've done here is to sort of insert redomiciliation into the picture, just to enrich the narrative, right? So you're going to see, a case where usually this tends to come in because of the CFC regime, the Controlled Foreign Company regime, which is sort of tax-driven. You'll see it in a minute. And okay, so let's start with redomiciliation before we get into the equity debt swap, or debt equity swap rather. So here I say that quite a number of these transactions are sort of tax-driven, right? I say quite a number of them are tax-driven. And here I kind of point out the rationale. So essentially, if your profits come from a foreign company, the taxman under the CFC regime is able to deem those profits as the profits of the company within the jurisdiction, right? So essentially it looks into how the business is organized and says, well, we will deem it because we believe that that foreign company is a controlled foreign company, right? So if you look here, I said the home country, and most jurisdictions have this, the home country will treat targeted income and profits of such a company, right, as income and profits of its controlling shareholders, right? And this was introduced in the UK in '84 with the ostensible purpose of preventing profits from being diverted to low tax jurisdictions, right? And I then say that the legislation defines a CFC, the controlled foreign company, as a non-UK resident company that is controlled by a UK resident, right? Now, the reason I bring this in is not to get you into the tax, but simply to set the scene, right? So it's to set the scene for the first type of transaction. So here we say we have a situation where the company is historically British, right? Historically British, but over the years, this company has expanded in such a way that a significant amount of its profits is, the operative word is truly earned, right? So a significant amount of its profit is truly earned outside the UK. In such a situation here, there may be a strong view that the CFC regime is punitive. So your task as a corporate finance advisor is to assist the company to do a redomiciliation with the purpose of escaping the CFC charge, right? That's your, right? So what you want to do essentially is that holding company, that company in the UK, which is within the CFC charge, you really want to then move it elsewhere, outside the regime, right? So that's a corporate finance issue. The tax lawyers simply say, this is what we want, then you say, I can do it for you. Now, remember, if you pick up the Companies Act, there's no provision in the Companies Act that talks about this, right? So we fall back on the tools that we've studied to get it done, right? To get it done. So let me repeat this, just so that it's clear. Let me repeat this. Before I get into the analysis, let me repeat this. What we're trying to do here, right, just to be clear, what we're trying to do here is bring what you've studied. There's nothing I'm going to talk about now that you've not done. I'm just setting the scene with the CFC. It could be something else. Somebody could say, I don't like your jurisdiction, I want to get away, right? I don't like your government, I don't like Brexit. It could be anything, right? So if I say CFC, I'm just expanding your horizon. Don't panic, don't fret, whatever. We could change CFC to Brexit, right? Does that make it easier, Brexit? Because I think people are freaking out. Oh, we've not done this and all that, right? I'm just, okay. So somebody says, how do we take our UK company into a different legal system? That's all, right? And I say to you, well, if you check the Companies Act, you're not going to see a section that tells you how to do it, right? But my point is that you already have the tools to do it. You already have the tools to do it. And what are those tools? They're the tools we've been studying. And I've always been saying that these tools are there to be applied instrumentally, right? And the larger academic context, right? Because, you know, academics, we always like to give things a context, right? I'm saying the larger context of this is life cycle theory. You may say, what does this bring to the picture? It doesn't really bring anything, it's just a context, right? This life cycle theory, because, well, it gives us order. It gives us order, right? Because we're telling a story, right? So far, we've kind of talked about how we raise money. You already know that. So now, we don't like Brexit, we want to get out. That's stage 2. Then after that, we continue the story. We have problems, financial problems. How do we solve our financial problems? We do a debt equity swap, right? And we're successful. And then the story continues. Now we're very rich, but we're greedy, right? We're managing the company, we're greedy, we want to make money for ourselves. We don't want, why should we be working for the shareholders? So what do? A private equity deal. That's why I talk about the life cycle, right? Okay. So we come back to redomiciliation. So we want this company to go out. How do we do it? We do what we call an inversion transaction, right? So the idea is to bring about the cancellation of the ordinary shares of the old company, right? And now you know that to do a cancellation of shares is a reduction of capital. You see, it's a reduction of capital, right? And usually, you know, when you're going to then do a cancellation of shares with a view to recapitalizing, you bootstrap a scheme of arrangement, right? So reduction of capital within the context of a scheme of arrangement. So basically, we take this our company, which we want to move elsewhere. There's the share capital fund, remember that treasury box? So we do a reduction of capital. We go back to that seminal reduction of capital, right? And it goes to 0, right? So the cancellation of the existing ordinary shares of the pre-existing holding company, and then the resulting reserve, right, because when you cancel it, you create a reserve, is applied to issue new ordinary shares to NewCo. So there's a new company in that your new jurisdiction. Now, in consideration for the issue of these new ordinary shares, right, NewCo allots and issues ordinary shares to the former shareholders, right, of the old company. So we whose shares have been cancelled, we've got to get consideration for the cancellation, right? So we whose shares have been cancelled, we're literally exported into the new company where we basically would have new shares. Then I say essentially it's a 2-step process whereby shareholders give up their shares in the old company for shares in the new company. And then reorganizing the group so that the non-UK assets are owned through the non-UK part of the group. So that you then end up with a top holding company and a corporate structure which is tax resident, just a minute, which is tax resident in the jurisdiction of redomiciliation. Now, so the tools to achieve this, sorry. So we employ a scheme of arrangement under Part 26. Right? So we employ a scheme of arrangement under Part 26. There are a number of things you need to look at, right? Because the shareholders of the old company, things you need to look at. The shareholders of the old company will not want their protection to be reduced. So what do I mean by their protection? I'm referring to UK company law issues, right? So for instance, if you think about it, one of the things as a shareholder I would have would be control of the capital structure, right? That my rights to rights of preemption, for instance, right? Because that's important. I don't want to be diluted, right? If you're advising your shareholder friend, you don't want to be diluted normally. So English law protects you. Remember we talked about capital structure, Section 551, the rights to authorize the directors to issue shares. So if we're going to be redomiciled in a new co, in a different, we don't want to be redomiciled to some jurisdiction where there is no protection at all, right? So what you want to do is choose a jurisdiction which is near the UK. So normally in practice you'll go to Jersey, right? And then so the framework of Jersey company law is kind of similar, right? And also you don't want to lose protection of the takeover code, right? Because you know the takeover code, if you're a shareholder, if a takeover is launched for the company, the takeover code basically protects you, right? Gives you a mandatory bid and so many other things. Guess what? Jersey applies the takeover code, right? And then another thing you don't want to lose protection of is the code of corporate governance, right? So again, you can build all this into the constitutional documents of that jurisdiction. So the template of the jurisdiction is provided by the law, which is the law of Jersey, and then you make sure that the things that Jersey statutory law does not deliver, you do this contractually. So that basically means shareholder protections there. The shareholders will want their UK protections not to be diluted by a redomiciliation. You'd also want to make sure that central management and control must take place in the new jurisdiction. In other words, board meetings and things like that should not take place in the UK. Otherwise, the taxman will say, sorry, I don't recognize what you guys are doing. Right? And therefore, right? And then, because you will have creditors, because you would have signed syndicated loans or whatever, you need to check your change of control provisions, right, in those agreements, right? Because that could be an event of default. Right? That could be an event of default. So you'll need to check that. Now, I'm just going to show you a deal, just a minute, just to bring everything together, where, so, okay, so if we look at this, I think,
It's not a key drive.
no, I'll upload that. So essentially, if we just look at the letter from the okay, let's look at this. Why is Beasley proposing the scheme? New Beasley has been incorporated in England and is tax resident in the UK. The scheme will establish New Beasley as the parent of the group. And it says that in 2009, the corporate structure was, with the approval of the shareholders, changed by putting in place a new company, parent company, incorporated in Jersey. Just again, that's usually the favorite jurisdiction, with tax residents in Ireland. And then it then says the directors believe that the UK is the optimal location of the management. It goes on. Why is it implementing the introduction of a new parent company by way of a scheme of arrangement? The scheme is a procedure used to carry out corporate reorganizations. We've said this. Then why is the reduction of capital being used? The purpose is to also create distributable profits, blah, blah, blah. Again, we've talked about this. So I'm going to upload 2 documents, which would give you, I don't want you to go into the full details of everything, right, because it covers many other things that they've bootstrapped. But basically, there are 2 documents. This is the circular, but also the prospectus. But please, it's a lot. The prospectus is about 130 something pages. I think 139, and I do not want you to go and start reading 139 pages. The point is, just go through the letters of the chairman, right? And then you'll know. So essentially, this is a bit of a complicated deal, right? If you notice, they're also trying to create distributable profits for future things. But the point basically is they are using a reduction of capital, but start with a scheme of arrangement to do a redomiciliation. You wanted to ask a question?
Yeah, you said that they cancelled the ordinary shares, which will result obviously in a reserve. What's the reserve for? Do they transfer the reserve to the new co, and then the new co issues paid up share capital?
Yes, because essentially the shares in NewCo have to be paid for.
Yeah.
So you're using reserves as payment.
So it would need to be
So
the reserves are transferred to
yes,
the UK. And
exactly. Otherwise, how do you pay for the shares?
Yeah.
Okay. So now, so having said that, right? So at least now, so remember, please, the context is not terribly important, right? As in, when I'm in the context, why you do it, right? There are many reasons. I'm sure after Brexit, right? I'm sure after Brexit, well, so many things like this are going to happen. The worst case scenario would be the introduction of exchange controls. That would be, I mean, I think, because if that happens, I mean, the shadow chancellor has already started talking about that, and if that happens, you're going to get a lot of these, corporate redomiciliations, right? Because you want to avoid exchange controls, right? And if you want to avoid it and avoid punitive labor taxes, so how do you do it? You would be doing these sorts of deals, right? And I remember when Obama was there, there were a lot of inversion deals away from the United States, right? And I remember the U.S. Treasury put out a document then trying to make it a bit difficult, because they couldn't get authorization in Congress for a new law blocking it. So what Treasury was doing was just trying to make it difficult during the Obama time. Now the opposite is the case, right? Whatever you say about Donald Trump, at least he's reducing taxes and all that, so people are bringing their monies back. Not that I have any admiration for him. This morning I checked the news and discovered it was like fighting a dead man, complaining that McCain was not grateful to him for his funeral. I mean, this guy is crazy. I mean, he's a nutcase. But anyway, I proceed. Yeah, not about the nutcase.
No, I was just wondering, in the scheme of arrangement we talked about before, are there no tax implications? Are there not capital gain tax or anything when they cancel all of their shares and basically get shares in a new company? Is there no tax at all?
No, there would be. There could be. Obviously, you'll get tax advice for that. But obviously, if there is a gain, right? If there is a gain to a UK taxpayer through this transaction, then the revenue would say, where am I? You need to pay your taxes on it, right? Whether you treat it as income or as capital, but there has to be a gain, though, right? So for instance, in me taking shares in NewCo, right? If I register a gain one way or the other, then the taxman will be interested in it. Then the dispute will be whether it's income or whether it's a capital gain, right? Because then you have different rules which would apply. So we now come to the restructuring per se, proper. So imagine the company remains in the UK, right? So remember, the whole purpose of the redomiciliation thing was just to add, to just complicate it slightly. So imagine the company remains in the UK. We don't really, there's no Brexit, and Theresa May, emerges the hero, the heroine.
The company is the UK.
Yeah, exactly. So the company is, the whole business of redomiciliation was to move away from the UK, remember? But now we're not moving away because Theresa May has solved the Brexit problem, right? She's going to go down in history like the next, Winston Churchill or Margaret Thatcher. And we're all very happy here. The economy is doing very well. But then the company runs into financial difficulties and they come to meet us. What do we do? What are the options? So we talk about restructuring. Usually there are 4 types of restructuring in the literature. There's managerial, operational, assets, and financial. So here we're really looking at financial, right? So managerial is simply changing people. Operational, you're basically changing processes. Huh? Assets, you're deploying, assets to different uses. Here we're talking about financial. There are 2 types. You have equity-based and debt-based strategies, right? And some of the debt-based strategies we'll talk about, but and I'll give you an example of how this could arise. Again, sometimes I kind of draw upon practice. There's a case which is online. It's an ICSID decision. This case deals with a power plant, and I was the expert in company law for Standard Chartered Bank. Interestingly, the other expert was the chap. If you read the case on bonus shares, you'll see where MAB is referred to, right? As the counsel there. He was the expert on the other side. So which was quite interesting because the issue really was whether if a managing director reschedules a debt, right? If a managing director reschedules a debt, does that bind the company? That really was the issue. So do you see how it comes up? So here was a company which was struggling, right? It was a power plant producing power and all that. And so they go to meet the creditor. In fact, the creditor had sold the debt. Because the original creditors were in Malaysia, so they assigned debt to Standard Chartered Bank. The Standard Chartered Bank were the new creditors, and so they go. So the managing director basically says, let's reschedule this debt, let's restructure it. No big words, but essentially all it did was reduce the interest rates, right, and then increase the duration, right. So reduce the interest rate and increase the duration, and that way it was a bit easier. Now the issue then was whether, when the managing director did this, whether this was an act that bound the company, right? Now, obviously the company took benefit of it, but at this stage the company was saying, when it doesn't bind us, and the larger picture basically was, the company was arguing that way to avoid triggering the application of a bilateral investment treaty. It was a bit more complicated, but you don't need to know that. The point is that if a managing director, right, restructures a debt, right, without board authorization, does this bind the company? Now, again, if you look at your seminar notes for last week, where we talk about legal issues, again, legal issues that you need to consider when doing these deals, in that list you'll see recapitalization, but there's also constitutional authority. Remember? So if you, in fact, that probably would be the first one, the first item, that constitutional authority. That's how this is. I mean, that's the context in which this is manifesting itself. So the question is, Obviously, the only difference is that it's manifesting itself not in a transactional way, but in the course of litigation. But you know, we only have litigation when transactions don't go well, right? So somebody should have ticked that box at the beginning. Do we have constitutional authority? Right? Do we have constitutional authority? The fact that, and I remember, you know, obviously my argument was to say, yes, there was constitutional authority, but the problem I had was just the MD. And so I then tried to argue that there is a ruling company called the Ruling Talkbrand. I don't know if you've heard of it, the Ruling Talkbrand. It's basically a rule which says that matters that are internal are deemed to be done correctly. Right? Because we, people on the outside, we don't know what's going on inside. Right? That rule, the Ruling Talkbrand, Turquand, is simply there to protect third parties who deal with the company, right? We don't know what's going on inside the company. We don't know whether the managing director told the board about this good news that the creditors have agreed to reschedule. We don't know. All we just know is that there's this rule that deems everything to be done correctly. So that really was my argument. In the end, the case actually was resolved on jurisdictional grounds. So, you know, so even if you Google it and you see ICSID and you see it, you're not going to see this discussion because the courts, you know, with many tribunals, I'm sure you probably know this in arbitration, they always try to resolve matters on jurisdictional grounds because it then stops them from going into some of the heavyweight type issues. So that could be something because if there is financial restructuring, you need to look and say, did they get authorization? Is there recapitalization risk? You know, just go through that list again and again. Now, we're talking about equity-based strategies. What are equity-based strategies? You issue shares, you reduce dividends, you know, the very things we've been talking about. So nothing is new here. So equity-based strategies may involve dividend cuts, issuance of shares as a means to retain or generate funds. Now, when it comes to issuing shares, what are the big issues there?
Dilution.
Sorry?
Dilution.
Dilution, exactly. Dilution, that's the big issue, right? So basically, you need to convince your shareholders who are in a ship that is sinking that it is common sense to take a long-term view. You know, rather than be top dog in a sinking ship and then drown. You know, why not just put your greed to one side and be a small guy in a ship which is floating? That's the narrative, isn't it? Right? Because at the end of the day, you want them to authorize you to waive their preemption rights and such like. So, phase 1, remember, you guys are doing phase 2. So we're doing phase 1 now. So this company has a huge debt burden, and what we want to do is focus on the equity side, not the debt side now, the equity side. So, and we're not talking about issues of dividends. We want to restructure the share capital. Right? So how do we restructure share capital? And later it's balance sheet. The way you do this is you try to get lenders to take equity and release the debt. How is this to be done? What are the key points of the deal? If you have a term sheet, what are the key points of the deal? Right? So what kind of assumptions do you think we should use here? Right? Because obviously what we want to do is if half of you are creditors and half of you are shareholders, what will be the deal points? Would you ask the creditors to put in new money? Would you tell them to bring in new money?
They probably won't want to.
They probably won't want to, but I mean, it'd be worthwhile to convince them to bring new money. would you not also be arguing about the kind of rights they should have? And why do you think a creditor would be interested in taking shares in the first place? Yeah.
Because his debt is valueless when, like, if it's gonna go bankrupt anyway.
Yeah, exactly. Well, unless, of course, they know that if they're quick to move, right, they'll be able to, you know, so for instance, that's why you have like pre-pack deals. So you move quickly, you sell the thing off, and you go. So it's really a negotiation of those kinds of issues, and then down to even how you configure rights. Because what if the company just has a temporary cash flow problem? So the future is bright, the company has a temporary cash flow problem. In fact, the company will be the next Facebook, right? So what do you then do? If you're the creditor, what would you do? Would you not be interested in taking warrants? Remember we talked about warrants. If you go back to Seminar 2, we talked about warrants, which give you a right to subscribe to shares, right? And so essentially, you might want to also take, say, preference shares with a coupon that mimics the interest rates, right? So essentially you're changing your status from being a creditor in legal terms to being a shareholder, but the coupon is essentially similar to you being a creditor because, you know, so maybe you have a 5% coupon, 3% coupon, whatever. It approximates interest rates in the economy. And if there's a return of capital, you get your principal back, right? And, you know, so those are some of the things you want to look at, right? Likewise, you know, but why is this company having problems? Is the management not too good? What can we do to change management? You really want to be able to control the board. You want to be able to negotiate rights that allow you to appoint new people, right? Who will, so long as you're not going to be regarded as a shadow director. Because if you're regarded as a shadow director, that's as if the bank is regarded as a shadow director and the company then goes bust, then the bank itself could face liability under Section 214 of the Insolvency Act for wrongful trading, right? So you want to make sure you have some key people driving the company forward without exposing you to liability for being too dominant in the affairs of the company, right? And you know that there are cases which say that it takes little to become a shadow director, right? So if you give guidance, and the guidance is always followed, the court could easily say, you know, you're a shadow director. We have cases on that, you know. So the point though is that the people who will have the upper hand in any negotiation will be the banks, right? Because you clearly, I mean, you're broke. Broke people can't negotiate that much, right? So you're broke. So the bank will drive this. So essentially, the meaning, it's a capital reorganization, usually of a distressed company in which the creditors convert indebtedness owed to them by the company into one or more classes of share capital. So here, in looking at those key considerations, in looking at those key considerations, which ties into the structure, I would say that before I get into this, I'd like to just compare with other possibilities, right? So what we'll do, we'll take a 10-minute break. We'll take a 10-minute break at this point. Very quickly compare with other possibilities for corporate restructuring, and then quickly move into the structure. By now you already know the structure. Where we're going is 583. All right, release. So just a couple of chase. But so let's take a 10-minute break. All right, you can get your coffee to rev yourselves up for this next bit. Yeah.
快把它倒出来。本来它是根部控制外地，现在它外地控制内，这样才能把税分清。惯性的就更多是倒什么情况？那就中国现在也有这种规则，原来没有，现在也在这个很复杂，这个是一个专门怎么运用，怎么个界定，它不是所有的收入，它区分你的所得地等等这些税率高低，它全部都有，所以它这个制度不是说这样的，它只是给咱们提供一个 background， 这部分因为这个原因，所以要换到外面去，所以你们咱们这个课怎么才 restructure， 就是这么意思，不是说这个给个铺垫，那是税，你这不用学，你这学了我怎么吃饭？我只是突然想到，中国也有，中国是学英美的，但是中国这个开展的制度有了，但是执行方面还是比较少。因为你想啊，我在海外之前，那我就海外强的如果在国内的申请，然后来进行这个教育，就是跳过对，有这种，现在很多的公司，外贸公司啊什么，他会把那问题截留在香港，省得再汇回来，这出去多麻烦，对不对？所以我们就大力提倡，但是以后就很麻烦。你 CRS 的话，你这个个人存款账户如果超过一定数额的话，要相互通报，所以你这又麻烦。就是其实不是是另外一个，就是你在境外的账户要通过信息交换把这个数据传回给中国，所以以后就更难了。但是呢，也有办法。你这账户你去买房呗，你买个房也可以。你干嘛要把别人现金啊？就跟现金交易你交流不需要有。所以嘛，就是你不能两全，就增加咱们这个原来有多少钱？原来是你可以放心放在里面，无论多少钱，现在是超过一定额度，200万美元、100万美元以上，那么它就得报，那么要么控制在以下，要么就比如说转化成不动产很多它信息会交换过来，香港税务局啊、新加坡税务局会把信息传给中国去。但是数量海量信息的话，能不能查到你这是另外一回事。但是你要按底的，他哪天不高兴了，翻了5年前的东西，你都可以翻出来。所以就是老是让人听到的，有些富人，我觉得这个事情一搞，一些富人都露出水面。以前我在税务局的时候，他们就打电话说。说你多少钱啊？平时装的挺穷的，以后国外要多少万美元？他们现在谁没有在国外多少万美元？下来，挺有钱的，原来不超穷。哎，下周还有课吗？
下周这个礼拜。
哦，case study 吗？没说。
应该不是吧 ？case study 不上过。
哦。其实这个课上的还挺扎实的，但是tutorial没上，至少就相当于讲2遍儿。
tutorial没记，
我也没记笔记，这东西，但是我觉得
不是他那个，
而且关键那哥们讲太快了，有些状态好的时候我听得挺好，有些状态听得差的时候我听得挺好。所以这个不知道考试，哎，考试几道题了？3道题。
好像是2+1还是1+1的。
是我忘了。
哎，但是我觉得1+1的好像似乎有点紧张。1+1的话，2个小时时间还是够的。它虽然即使给你 essay 的话，你要思考，读完思考这个，但关键是他要给我4道题选1道的话，我第1道看到我不太会做，看第2道，第2道看完我也不会做，看到第4道题以后我还不会做，那我选哪道半个小时过去了，就有点这种感觉。
跳过分数题的几个分数题为什么要做下去？
Yes, it's kind of, it's very similar because they take you, well, you didn't start in Westminster because Westminster Station was used for one of the movies. In the film movie, when Harry is taken to the ministry to be judged because he used magic outside. The station where they walk through is to Westminster. And the funny thing is that they wanted to use Westminster because in the book, Rowling referred to Westminster, but the truth is that it was horrible for regular people because they closed Westminster Station. So everyone stayed at Westminster. Because the tour guide said that usually there are like ghost tube stations that are not used anymore, but they are still like usually it's a thing, yes, usually they are used, but usually one would be very well. So they use Westminster Station. So we start there, and then they take you to the entrance, like the visitor and the employee entrance to the ministry of magic, because you don't have, so they tell you that's the visitor entrance. But they also show you that it was actually like they show you pictures of the actors, like they show you music working, standing. So it's kind of fun and you walk, and then it all the way from Westminster to Pollard Square. They had like one of the very color part to it. I think it had the world record for the longest red carpet because they put it like all over. And they take you to the original and the original Nocturnal. It's middle of stuff. It's near Soho. Like it's those are the alleys where J.K. Rowling based her stuff. Like this is the alley where J.K. based. Yeah, and like it's the original alley. Like she hadn't liked when she came up with it. And then this is the original Nocturnal and even the windows and everything. And it's also like walking like good. Yeah, and then they fall.
Actually,
that's what happened to me when I started
that's why I was like, this is a double.
there's another company that was doing this for
Mine was, you can see,
Wait, what?
at the end of the
Oh, with the Formula One? I would have liked it back. For sure. But it was below 100 centimeters. But I'm not sure how much that tells us. Yeah.
I don't think you can see it at all.
It's not the only skyline. It was like a whole picture.
But I think it was the best year because Apple Rock, it was only once in the year, and
Don't have a train. I'm in need of the medical system.
I heard about it.
He's probably on quite high expectations. literally fortunate. Gets out the lecture.
Take up one.
Are you going to live?
Today,
Yeah, after the usual.
I forgot my
Yeah, I've forgotten to like every weekend since we started. So Tom is stupid as me. It comes to every time I get the email. It's like stupid, and I'm so oh great. I've forgotten to buy it again. Because I've lost boundaries of time.
Use my website.
Yeah, I can't even go away. I tried using Westall, but it was so slow.
Okay.
No, I
Yeah.
just used the...
Is anyone missing in action? It looks like some people are. But let's just wait for a few minutes.
Still would like to know why it has to do benefit of the company or the bank. We will talk about that. Means getting a loan in this month last week. That's taking the loan for the banks or what the issues also like all of these things. Is one of them was implemented for the benefit of the company. Why do they care?
Is that in... Well, I think it's because one of the directors take on, the directors taking on a really big loan.
yeah, what
But the company doesn't have prospects to pay on.
what's the point of giving it?
Is that loan in the interest?
Okay, so here we I did say that we would sorry, can I have your attention, please? Thank you. Thank you. So I did say we're just going to very briefly compare it with other types of reorganizations. Normally you have a CVA, which would be a company voluntary arrangement. I'm sure many of you know this from your insolvency classes. Usually a compromise with creditors. So essentially, you're telling the creditors to take a haircut. This has nothing to do with a restructuring of the share capital, right? And then you also have administration on kind of Chapter 11. And then you have a scheme of arrangement, which obviously can be used to restructure a share capital. The scheme of arrangement is so versatile. It's a beast. It's a beast of corporate finance. You can use it to do so many things: a demerger, a takeover, whatever. A cram down with creditors, a redomiciliation. It's just an amazing statutory instrument of great versatility. And if you look at just the case law, so you see this, just to give you an example of, if you look at Holdco, if you read the facts, essentially you see a scheme of arrangement, being used, right, to restructure the the existing capital structure of the company. So if you look, I think in paragraph 9, it says the proposal was that the existing rights of senior creditors should be replaced by a mixture of debt and equity in the case of the holders of fixed rate notes, and by equity alone in the case of the holders of senior notes. Right? In addition, Castle Holdco 4 will be cancelled, and intercompany debts owed by Castle 4 would also be released. That part of the transaction does not form part of the schemes, but was dealt with. The point, it looks complex, right? But it's not that complex, because all we just do is just gather everything and put it through a scheme arrangement, right? So, okay, so we're basically saying, okay, you have these notes, your creditors, you're prepared to take some shares, and the guy says, oh yeah, I'll take some shares, but can I also have some credit, keep some credit notes? Fine, we bring this in, right? Whatever changes we want to do, no matter how complex it appears, you put it within the scheme, and you send it to the court, so long as it does not involve surrender or forfeiture, the courts. And so long as you get the head count, the 75%, then fine. Everything is possible, right? So don't say to your clients, the surest way to poverty, as a corporate lawyer, you say, oh, there's no section in the law, we can't do it. You won't be a very successful one. So everything, yes, we can do it, even if you can't. You check it out later. Because the other people who are saying we can do, right? So you've got to be positive. Anyway, so here, we're looking. Remember, I said I'm going to just focus on the simple debt substitution, which is section 5A3, which is the more sort of complex one, right? And that's why I want to talk about it. But it's not complex to you now because you already kind of understand it. So the simple debt equity substitution, right? Debt is released by the creditor. The release is payment in cash under section 583, because we know section 583 defines payment in cash, right? That shares are allotted, right? If non-equity shares are issued to the creditor, then preemption rights in section 561 will not apply, because remember, we talked about preemption rights, right? And one way you can do it, you get around that, right? The newly funded NUCO is straightforward, so I'm not going to waste time on that. So, what are the commercial considerations? Is there new money? Who is provided it? The size of the debt to be replaced. Now, the size of the debt is important because if the debt is so big and you convert it into shares, then the risk is that two risks. One, if it's a bank, that company could become a subsidiary, and then it will have to consolidate, to prepare group accounts to consolidate it. The bank does not want that. Two, the bank could be subject to a mandatory bid obligation because they're acquiring 30%. Right? Under the takeover code, if you hit 30%, you have to make a mandatory bid for the company. Right? So two things you just don't want to deal with is the obligation to consolidate accounts and the obligation to make a mandatory bid. I mean, the mandatory bid, you can find ways around that, right? So you apply for a whitewash. So what are the legal issues? Receipt of new money is a prerequisite to the substitution of the creditor's debts into share capital, right? So if you use another method, right, where you're not going down the 583 route, then you need new money, right? If you want to go down the 583 route, right, then you can avoid that. Do you see? So, right? And then if the company, then ensuring, assuming it's intended, that the company retains its listed company status. So, because the reason is that if the size of the debt is so large and, and the float, the number of shares floating on the market is, it goes beyond the 25% threshold, then you lose your listing status. Ensuring that a mandatory bid obligation is not triggered because of Rule 9. Now, a bank may see its shareholding in a company triggering Rule 9 following a swap. Then I said, in this case, you can avoid it with a whitewash, right? So you have to apply to a particular panel, and for them to grant a whitewash, right? Ensuring that the creditor does not have to consolidate the company subject to the swap in its consolidated accounts, right? So if you look at the definition of parent subsidiary, if you look, you'll see how easy it is to be trapped by that. And then obviously if it's a bank, you want to look, a bank, insurance company, at capital adequacy issues. And then ensure that the creditor knows the implications of the various shareholding levels, under the disclosure transparency rules. So when you start hitting those percentages, right, 3%, 4%, you need to basically comply with disclosure requirements. Tax and competition law issues. Competition law issues are obvious. Ensure that there's, remember I always say, unlawful financial assistance. How are you paying for those shares? All right? So you need to be sure that there's no unlawful financial assistance. Always good to have that in your checklist. Ensure that the shares are not being issued at a discount, right? Remember the Oregon case. The impact of foreign law, if any. How do we configure the share rights, right? So if the creditors are swapping their debt for equity, what kind of things? So we'll go back to how the debate between the debtors, the shareholders and the creditors, because obviously if I'm advising the creditors, I would basically want to have some degree of control. I would also, if I think the company has prospects, I'll be interested in the company's future. All right? So you really, what you want to be doing is you're thinking of redeemable preference shares, right? Redeemable preference shares. And you need provisions that will force the company to redeem the shares. Do you see? Because you don't want, it's one thing to have redeemable preference shares. If it is redeemable at the company's option and the company refuses to redeem your shares, right? Then in a sense you're just getting interest, you're not getting your principal back. As a bank you might, or a creditor, you might just want to get all your money out at some point, right? So if the company has enough distributable profits, you want to have a ratcheting provision that forces the company with its distributable profits to redeem your shares. Otherwise, you make it's either to redeem your shares or you make it too expensive for them, right? To continue to have you in the company with redeemable shares. So you want to do that. And certainly, if you think the company's future is good, you want share warrants, right? Which will allow you to subscribe for shares. Then also, should there be restrictions on the transfer of new shares? In fact, when we talk about the configuration of share rights, would you give the bank the right to vote?
You might not want to, but you might want to give them a veto right.
Yeah. Usually, at the end of the day, people have to kind of agree somewhere, right? Bear in mind that you don't have too much power.
Yeah.
Yeah. Okay. But there's no, it's always good to at least put your, you know how these things are when you're in negotiation. You go for something maybe higher, they will knock you down. You never go for your barest minimum, never, right? Then should there be restrictions on the transfer of new shares? Clearly, you'd want, as the equity people, to impose those restrictions. Then wiping out accumulated losses on the balance sheet through reduction of capital so that dividends can be repaid. So you're preparing for the future, right? So if you carry losses, you want to wipe out those losses. And we did this. Remember how we did it? We used a reduction of capital. That's why I say, a reduction of capital, a scheme of arrangement, amazing things to do. So much magic with, right? Provisions on fixed redemption dates. Right? Remember I talked about how forcing them to redeem early, right? So you want to have provisions on fixed redemption dates and provisions designed to encourage early redemption. class rights to prevent depletion of distributable profits and to protect other concerns of preference shareholders. So what does that mean? So I'm a creditor. I've been given shares, and I have preference shares, right? And if I have preference shares, then I want to be able to have a veto, as you said, on major things. Now, technically, that veto is a class right, right? Remember the Cumbrian case. The Cumbrian case tells us, when you read the Cumbrian case, we talked about the Cumbrian case on class rights, remember Cumbrian and Cumberland, where the judge said that rights attached to shares fall into three categories, right? And class rights would rights such as the right of veto, weighted voting rights would be class rights. And what does that mean? It means that the ordinary shareholders, because remember you hold preference shares, the ordinary shareholders cannot go and vote to change that, right? You can block them, right? But what if after concluding this, you have a preferential dividend rate, a coupon rate of, let's say, 6%, right? You're happy with 6% because guess what? Interest rates in the economy are about 6%, or even maybe more. So 6%. And then the other guys go back and reduce your dividend rate from 6 to 1%. What would you do? Can they do that? Why not?
That's section 5 something, where they cannot change one clause.
Okay. So two possibilities. They reduce to 1%, the other person they reduce to 0. Can they do it?
Yeah.
What can they do? What can they not do?
They cannot do the 6 to 1, but they can do the 6 to 0, as you explained.
Yeah.
Way back.
Way back, yeah. Why can they do to 0?
We just cancel it.
You cancel, yeah. And you say, and I mean, obviously that you would only do this if the company's fortunes are really great, right? So if the company is doing really great, because logically there'll be no reason for this if you have fixed redemption dates, isn't it? If they have fixed redemption dates, then you normally would just retire the shares on those fixed redemption dates. So the only reason why you're doing this is that you think, God, we're making so much money, we don't want these guys to be part of it, we just need to get rid of them now. In which case, if you're making so much money, they know you're making so much money, they want to be part of the gravy train, right? And they're saying, how dare you eliminate us? So if you reduce it to 0, you would have succeeded, right? In that case. So if you're advising the bank, how do you stop them from doing that? How do we stop them?
Get a veto on reduction of capital as well in general?
Yeah, well, you go in there, you say that the clause dealing with class rights would say that a reduction of capital shall be deemed to be a variation of class rights. Right? A reduction of capital shall be deemed to be a variation of class rights. So by so doing, because it will be deemed to be a variation of class rights, you get the veto. So I like the way you did it. You caught the chase, you got straight to it. You may not have known the route to follow, but you got to the right destination. Or you may have known the route, but you're a master of brevity, and you just went straight there. Right?
When you cancel the shares in that situation, what do you give back to the preference shareholders? Do they just get
Their
the
capital.
capital? Just the nominal value. Good point. So it would be the nominal value. However, if you're advising them, you want to put in what they call a spends formula, a spends clause. After the lawyer who came up with it, this was way back. Some QC came up with this clause basically to
reflect the real value, right? Especially if, so imagine the company is quoted on the stock market, we can tell that the value has gone up. So you track that, because if you don't do that, then they just get the nominal value. So you can see these are the issues that would form the core of your negotiating points, right? You know, and then shareholders agreements, obviously if it's a private company. So now, what I want you to kind of think about is the next phase, right? So here you are, you know, we're looking at the equity and debt aspects of private equity transactions, right? So what has happened is that following the debt equity swap, you know, which by the way has been, you know, successful, the company itself has become an unmitigated success. And you know, the management team, like every economic actor, right? They're rational, and if you're rational, you know, why should you work for other people? You work for yourself, right? So you would want to take over the company from its existing owners. So the problem now is that there's a conflict of interest, isn't it? Because you know where the real assets are. You know where the converse of knowing where the bodies are buried. You know where the jewels are. You understand the business better, and yet you want to make an offer to the shareholders. How can the shareholders be sure that you're not taking advantage of them? So there is a serious conflict of interest in this scenario. Now, obviously, to obtain the funds, you will invite a private equity fund to join them. The private equity fund itself would want the transaction to be leveraged, right? In other words, they would want to load a lot of debt, right? So that way they can take advantage of leverage. So they invite two banks to provide finance. So what we're seeing here is the various participants to play out, right? So the shareholders of the target, you know what the key issue for the shareholders of the target. You know, are you basically, you know the word, are you really trying to mess me up? I've used a very polite word, right? By the way, but I think you know what I mean. All right? So that will be the concern of the shareholders, right? And so we want to look at how to protect them. Then the management of the target, obviously. Then the private equity fund investor. Then bank one, and we'll bring in another bank to provide mezzanine finance, you know, so junior debt. And so the question is, how do we work with this deal structure to deal with the inevitable conflicts of interest and, you know, how you layer things, and right? That's really what I want us to do. Thank you. So down to security. So I want you to apply your learning on security. What sort of security do we use? How do we do it? Should there be any kind of subordination, right? Because with this, right? So, and if you're going to be thinking about subordination, what kind of subordination is structural subordination, whichever, right? So I want you to think about that so that we have a really interesting discussion, right? So here, and what I've just done here is provide some of the points. I've said these private equity transactions cover a wide variety of arrangements, you know, management buyouts, right? So here, the rationale is stated as part of management, as part of a management buyout with a view to a return in the form of capital appreciation. So what's the structure? So I've given two types of structures, or at least the common structure here. And then the equity. So what I've done is to separate the equity finance points from the debt finance points. So that way we'll bring everything together. So if you look at the equity finance points, the investment agreement, right? The investment agreement obviously is key. The articles of association, right? So a lot of the configuring that we've been talking about will happen there, right? Because if you're going to be designing share rights, it's going to be there. The share rights will be in the articles. The investment agreement deals with other things. Huh? So for instance, key man insurance, you don't want the guy to die. He could have a heart attack. What happens? So, and then, debt finance structure, right? So, again, you might want to look at those cases and then the legal issues, security. How do we regulate the priority or defend the priority of the lenders, right? Because here we have two lenders, isn't it? So junior debt, senior debt. So you need an inter-creditor agreement, right? And then warrants, and then obviously because of subordination. Remember I talked about subordination. I'd like you to think about subordination, right? So that would be it. So I would like the class to be divided into the two groups, right? If I don't want to call on anyone or appoint anyone, but the point is, I would like some people to focus more on equity and some to focus more on debt. Obviously, you need to know both. You can't go and say, oh, I'm just doing equity, I'm not going to do debt, right? But just focus more, right, on equity and some to focus more on debt. And then when we're talking, I'd like to just sort of, I know everybody's sort of ossified in their current seating positions and they'll be so resistant to moving away. But all you need to do, so I'm not going to ask you to go to equity and go to debt because I know you won't. So all I'll just say is just let me know when you're answering whose side you're on, right? If this was a dictatorship, I would say wear red, wear blue. But I know the limits of my power. So anyway, let's meet next time and we'll do this, have an interesting discussion. Okay then, thanks. I have my list, okay, yeah. And if you've not provided feedback on the forms, the online thing, please do so. Usually those who are satisfied rarely do provide feedback. The people who are not satisfied are the ones who provide feedback, which has a very distorting effect. So if you are satisfied, you're encouraged to provide feedback, right?
How do you avoid the consolidation problem when swapping debt to equity? By local accounting laws and all that sort of stuff? How do you avoid the consolidation problem that the bank doesn't want to? It's not insolvent yet, but just the stress balance sheet. Yeah. How do you avoid it?
Well, obviously one thing you do is you make sure that they don't have. So for instance, if they take other instruments, right? Which because you see, it's key. What's relevant is control, isn't it?
Yeah.
And that's tied to the definition of equity securities. So you configure more non-equity securities, you see, and then rely on setting contractual provisions for control, right?
So you want to avoid having control, but still have some sort of control.
Exactly.
It seems like a very petite line to walk.
I know. It is. Yeah. So, and that's why the size of the debt is key, because you might want you really don't want to be toying around at that point.
Thank you.
Yeah, you're welcome.
Could I email you about some further reading on restructuring? Because I find it really interesting.
Okay, please do.
Sure.
Yeah.
Thank you.
What's your name?
Thomas.
Thomas. Okay.
Thank you.
Hi. Hey there. Yeah.
What do you want to read? My
Yeah. This is the other triple. Yeah.
private equity that will be useful for private equity. I think I'm gonna do that because that's like, I like the debt side with all the because it reminds me of this. Like I like technical discussion of upstream guarantees and all this. Yeah, but that's why you smile when you get sex. Yeah, I love to talk about it. I'm like, okay, but I can't decide to take it with my presentation. I can't put a footnote. My Nexus at this.
The last tutorial where you started you looked at
Get your go. You're like, I look at David Winfield.
Thank you.
Thank you, thank you. Cheers, yeah. Yeah, see you, yeah. This is a company law class, right? You're still doing loan finance, yeah. I would have probably liked me if someone started that issue. I think that, yeah.
There must be. Oh, there is one near the stairs, down to this floor.
Oh yeah.
There's one
Like
near
near
the
the door.
Like, you know, on the way to the girls' toilet,
Yeah.
you see on the left.
Okay, but like
It's next to the prayer room.
Okay.
Near the lifts, near the lifts.
Okay.
Yeah.
Thank you.
I don't know because I think it's not. Right? I was like telling that it's not a very good outcome. Two people thought it was exclusively about. No, but that's just the question as though. The thing is, like, even the UK, corporate governance code is also considered as like newspaper. Sort of. Like, no matter what you search, they actually put it as under company law. Yeah. Okay. I'm gonna talk about it. I just started, so I won't. Oh, you can chill. You only have two. It's still Alexandra, right?
I guess.
Yeah, it is. Yeah, if it's her name, then it's whatever.
Last class is guy. Right?
No. It's just she likes to last class.
No, I mean like it's like one of the last times.
Oh, yeah, this?
class next week? I don't know.
No.
We think we
We
have
don't.
class, but I don't know if we have lecture.
Oh yeah, I don't know if
It says revision.
because I know some modules are just doing their revision at the end.
Right.
But
We
I
should
don't know
ask
how many.
today.
Yeah. Have you looked at the private international question? Well, which one?
I'm gonna put the essay question.
It's
I have it 6.5.
Yeah, I'm not planning it. Like, I only do it under the I just look at it to know which topics are. So you're definitely not doing it, like, okay, so I don't know the problem question. Is it enforcement?
I haven't
What, you feel like doing more?
Yeah.
Oh, so you're gonna come for the last one.
I think it's mixed. I saw the questions, but I didn't understand the questions were totally
That gives us so I thought part of it was enforcement, but then I think some of it is in the contract.
Because it's injunction, right?
Yeah, but then I think some of it is one or two of them are become contract.
Okay. Can I? Yeah, sure. What do you want to say?
Disappear. No, it's
You
you might need a compensation, right? Like, and then, like when you're there, you're not in place. I'm used to how much it's more.
Oh, you're used to, should we have that?
Yeah.
Oh, no, I'm not.
I'm sorry, set up. Yeah, I always look like how's your week without me? We went to like another competition.